My name is Showkat Mukadam. I am a director of Legacy Fiduciary Services and estate planners. We're continuing with our series with regard to inheritance in Islam, and we're very fortunate to have Sheikh Muneer Abduroaf to assist us in covering the relevant topics. Assalamu alaikum wa rahmatullahi wa barakatuh, Sheikh.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Sheikh, one of the topics that often comes up is about children, who qualifies to inherit. And we're particularly talking about the children who are born out of wedlock, what is the situation with regard to them, and the situation with regard to children who are adopted in respect of the testator or the deceased person. Could you kindly elaborate what the rules are with regard to this, and again, provide us with maybe a way of making sure that these children do inherit one way or the other if there are challenges with regard to with regard to the inheritance?
Okay, shukran for that question. It's quite an important topic because it refers to children, and the one would be the adopted child and the other would be the child conceived out of wedlock. Let's start by looking at the position of the child conceived out of wedlock. Now, in terms of Shariah, there will be a tie to the deceased, which is now the blood tie. However, the issue is with regard to whether or not that father the biological father was married to the biological mother at the time of conception. If the child was conceived out of wedlock, so Islam doesn't look at the date of birth, but looks at the date of conception. So if the child was conceived out of wedlock, then there's another condition that the child must at least have been born 6 months or more after the conception. If that be the case, there is an opinion that the Shafi'i also follows, and some other a minority opinion, the Shafi'i madhab as well, that the child would inherit if it was 6 months or more after the conception. If it was less than 6 months, then unfortunately the child would be disqualified. There are also opinions that says, in terms of Islamic law jurisprudence, that the child will not inherit. In both instances, the solution would be that a testator, right, who is now the biological father, can make a bequest, a wasiyah, in favor of the child, up to a maximum of the 1/3 of the net estate. That is now the estate after all liabilities have been deducted. And it could also be possible, if there's a number of children, that the bequest could be equal to the share that she or he would have inherited had she or he been conceived in wedlock. So it's important to note what options are available to the testator, because if this option is not made use of, it would then mean that that child would not inherit in terms of the will. The ruling, however, of the 6 months and conceived out of wedlock and born out of wedlock only applies to inheriting from the biological father. As far as the biological mother is concerned, the child will inherit whether or not she marries the biological father or not in this regard. With regard to the child who is adopted, the same applies because there is no tie. So Islamic law doesn't look at an adoption as a tie to inherit in terms of Surah An-Nisa, verse 11 of chapter 4. However, again, if the testator would like to make a bequest, a wasiyah, in favor of that adopted child, which could be equivalent to what any other son would inherit from his estate, that it would be possible, or any daughter inheriting from the estate, on condition, however, that it does not exceed 1/3 of the net estate in total after all bequests have been looked at.
Jazakallah for that, Sheikh. I think it was very informative to cover the situation of children born out of wedlock and adopted children. It's important if you find yourself in that situation, that you contact professional advisors to cover yourselves so that you ensure that those children inherit from you should you wish to. Contact us at Legacy Fiduciary Services for any professional help in this area.